My name is Marcia Hyde. I'm a barrister at 42 Bedford Row. I'm a family law practitioner and I'm head of the animal welfare group here at 42. I'm joined tonight by Amanda Jepson, who is also part of both the animal welfare and the family law group. She's a senior practitioner in serious care cases. And I'm also delighted to be joined by Erin Leach, who is a researcher in international human rights. Erin is currently based in Queensland in Australia, but I don't think you're there tonight, Erin. And Erin specialises in human rights and how you can apply conventions and treaties to make human rights work. Erin is also a member of A-Law, and I think a lot of people who watch our animal welfare webinars know that A-Law is a charity set up to explore the law and educate people about the law in terms of animal welfare. We hope to finish in about 45 minutes and have questions for about 5 minutes at the end. If we don't have time, please email the clerks. They'll ping your emails on to us and we'll get back to you. Similarly, if you want any documents that we refer to, particularly a copy of General Comment 26, which we'll be dealing with tonight, then again, please email the clerks and I'll make sure one is sent out to you. So the topic for tonight, before we get started, the topic for tonight is General Comment 26, which was issued in August of this year by the Committee for Children's Rights under the umbrella of the UN Convention on the Rights of the Child. And it's a really important general comment, and it does two things. Firstly, it highlights and recognises the link that we've talked about before on these webinars between violence against animals and animal abuse and violence against humans. So we know, for example, from research that if there is violence or animal abuse within the family, there is likely to be child abuse or domestic abuse. And research tells us that correlation is very, very high. So for child protection professionals, animal abuse is really a red flag, pointing to other forms of human abuse. So General Comment 26 reflects that, but what it does in a different and what we think is groundbreaking way is it links for the first time animal welfare and animal rights with human rights. Because what General Comment 26 actually says is that children should be protected as a right, as a human right, from being involved in, exposed to, or engaged with violence inflicted on animals. So that's really important. So the purpose of this webinar really is to highlight the task now for animal welfare lawyers and people who are interested in protecting animals is to how do we harness General Comment 26 to protect animal welfare as alongside children's rights and protecting children from being harmed by being exposed to animal violence. So if we look at General Comment 26 itself, which is the next slide, I think, Sophie, we'll see how wide-ranging, and this is only part of General Comment 26, we'll come to how big it is later, but the part that we are really, really focused on in this webinar is paragraph 35, which says very clearly, children must be protected from all forms of physical and psychological violence and from exposure to violence, such as domestic violence or violence inflicted on animals. Now that's hugely wide-ranging, and we'll come to look at later on, well, what does it mean? And specifically, how can we use it? How can we use it to protect children as well as animals? And when I was looking at General Comment 26, it slowly dawned on me that I know nothing at all about conventions. I don't know how they work. I don't know how they're compiled. I don't know how they apply. We all, of course, in our different disciplines know about the European Convention on Human Rights, and we use that every day in our different practices because we incorporated that into English law under the Human Rights Act. I know some people might not have agreed with that, but we know how to use it. So in family law, for example, we use Article 6, Article 8 of ECHR all of the time. But how do we use General Comment 26? And so that takes us to how do conventions work? And that's what we're going to explore with Erin through what Amanda and I thought the best way of doing that was to ask Erin a load of questions. So Erin, could I kick off, as it were, with the example I've just used, the European Convention on Human Rights? Now, is the difference or the differences between that and the rights of the child, the Convention on the Rights of the Child, is it simply one's European who signs up to it, or is it specifically because it deals with children rather than all humans? How do they work? How do they connect?
Well, so I guess like the immediate difference between the European Convention on Human Rights and then the UN Convention is those terms itself, how many legal instruments they actually refer to. Because we've got the European Convention, that's one core convention. And then when we talk about the UN conventions, typically we're really referring to those 9 core human rights treaties. And by extension, there are 10 treaty bodies and their committees and all of those materials that comes from them. Now, as you say, it is regional. I do think that the greatest difference between them is scope, and it is jurisdictional. So Europe has 46 member states, and then we've got the UN conventions that can possibly extend to any territory in the world and are open to them. But then we also have the scope of what rights are actually covered, the type of rights. And when the European Convention was drafted, I think it was the drafters that actually said that the social rights were too controversial and too difficult to enforce. And so they didn't include those in the convention, whereas the UN has specifically branched into the civil political rights, but then also the economic, social, and cultural rights. So there's 2 very clear branches that are a little bit more expansive, in my opinion, than the European Court of Human Rights is allowed to go forward with.
So for the Convention on the Rights of the Child, is everybody signed up to that? Who isn't, or is it easier to say who isn't signed up to it?
Yeah, it's the USA is the only state. It has signed up to it, but it's the only state that hasn't ratified it. And this is the most signed treaty historically in the world out of every type of international treaty. So the CRC is a big deal.
So what's the difference then between signing up and ratifying?
This is probably the stickiest question that we get. And I've got the UN Library's glossary here because this is probably the best way to define it. Signature, it really means that they've established, or the state has established, their consent to be bound. It doesn't bind them. But there's quite a lot of language around this. So by extension, they also say it is a means of authentication and expresses the willingness of the signatory state to continue the treaty making process. And the signature also qualifies that state to proceed to ratification, acceptance, or approval. But in doing so, it creates an obligation to refrain in good faith from acts that would defeat the object or the purpose of the treaty. So it's a very, the signature has a high pressure. It's not binding, but it's very close to binding.
And ratifying makes it binding? Is that how that works?
Yes, and the process of ratification by the UN standards is that a state would put it into domestic law. So they would incorporate it and make the international rights effective under their own legislation.
So do we know, have all countries who signed up to the rights of the child, the UN Convention on the Rights of the Child, have they all ratified it, apart from the states?
Yes, technically they have ratified, but, or sorry, no, not all have ratified. So for example, Morocco, it depends if you're looking at it as just the convention, so the CRC, because the CRC also has 3 optional protocols. So the majority of member states have ratified the CRC. I couldn't give statistics clearly on that one, but the majority have not actually ratified the 3rd optional protocol. So it gets a bit technical. And when you're talking about ratification, you have to really question, what does implementation mean? What does enforcement mean? And what does, if a state is saying that their laws are effectively applying the treaty, is that going to be the same standard across all states? That's a tricky area.
So although we have, well, let's go back. How do conventions change and modify? Because we know, for example, under the European Convention on Human Rights, we talk about it as a living instrument, as something that changes and adapts. And so how does that process happen?
It really does happen through a lot of different parallel mechanisms. So the UN works with charter-based mechanisms and treaty-based mechanisms. And really, we're only talking about the treaty-based mechanisms today. So the treaty bodies per each convention will have the opportunity to write various reports and comments. So that's where our general comments come in. General comments are essentially looking at the wider issues. It's in the name, it's the general thematic issues, but they can also be on the very specific issues. For example, you have the situation of street children was one of the general comments from the CRC. Then you also have concluding observations. So when a state signs up to the CRC, they are then under a responsibility to periodically report back to the UN to say that they're fulfilling or taking steps towards implementing what they have agreed to be bound by. And once the treaty body receives those reports, that's what they release in terms of a concluding observation. So they'll make positive observations, and they'll also make some recommendations for how the state can improve their record in terms of implementing the convention. And really, yeah, these are 2 of the main instruments that are used to keep the convention up to date. The general comments itself they have the character of soft law, and they're highly authoritative in terms of the interpretation of the convention. And as you can see with General Comment 26, they do have a tendency to be quite expansive in terms of expanding the original convention.
So I was just going to ask you on the general comments point and concluding observations, that they don't have the force of law that the CRC has in the countries that have signed and ratified it. Is that right? But they're just binding.
So they don't, the CRC has the technical status of binding. This is the issue that has been chased by most of academia around the convention. And the technical response to that from the UN is that the general comments have the character of soft law, They're highly authoritative in terms of the interpretation and should be followed, as should the concluding observations, but they are advisory. And it's also important to distinguish, and probably the most defining distinguishment between them is that the concluding observations are specific to each state they are responding to. So it's good general advice, but it is a direct kind of dialogue between one state and the body.
And if there's a disagreement between a state in terms of the concluding observations made, how is that resolved?
Well, you do see repeated recommendations. You do see general themes reoccurring. There's a lot of mechanisms that are growing that are looking to assist states in implementing different rights, whether that's investing in different local procedures. But another way that citizens can actually enforce their own rights is to use the individual complaints mechanism. So it's kind of the local versus international recourse for an individual that's had their rights violated. You've got the domestic courts on the local level, and then you've got the treaty body. You can file a complaint to them at this international level if the state has accepted the right procedures.
If an individual takes an issue with the implementation or lack thereof of following these general comments, for example, how do they take action, or can they not?
Well, what I personally think a benefit of that mechanism is that quite often the convention doesn't require that individual to have exhausted domestic remedies. So they don't, I mean, in a state who's not necessarily implementing those rights to begin with, it's highly unlikely they're going to get any kind of resolution in domestic court. So that avenue to be able to access another option, I think, is very important. And we do see a little bit of evidence now of some of the UN treaty bodies having states on their list of pending cases that haven't actually ratified that procedure. So it's definitely evolving. It can't be confirmed for certain at the moment, but I think there's some space there for that option to be available for individuals, regardless of what the state is saying.
So just talking about interpretation of conventions, Erin, and how individuals or groups can use rights within conventions. When we look at, do we use concluding observations and general comments to help us interpret situations under the articles within CRC, for example? Is that how we do it?
Absolutely. Your general comments would probably be the first point of call to help you understand the content of a convention. You can certainly go into the cases themselves as well. And there's a lot of different types of reports. One of the other mechanisms that exists under the UN are the special rapporteurs. So you have a lot of different independent experts that are reporting on very specific issues. So also feeding off of them, but the general comments and the concluding observations are right at the heart of these articles.
And so when we use them, do we have to look, when we look at, say, the CRC, do we also have to look at other conventions as well to help us interpret specific articles within, say, the CRC? So, for example, we'll come on to some examples later, but there must be some kind of clashes between conventions. Is that right? And how do we resolve those?
There are some clashes, but in general, there has to be a balancing between all human rights. They're human rights because they're owed to us inherently as human beings. So that balancing has to occur between the conventions. But then we also see some rights that have a particular status, such as the right to be free from torture, that has a slightly higher status than other human rights. But that does tend to take time to evolve, and it can keep the status of soft law. So it's not in itself binding, but just part of the way that we're trying to move through that, because it happens. Of course, there are clashes.
And when we come on to interpreting a concluding observation or a general comment, and we look at it in a moment, looking at paragraph 35, when we look at all violence against animals, how do we interpret within the general comment? Do we do it widely? Do we look at the rest of the general comment? Do we look at the rest of the convention articles? Do we look at the words within it to try and come to a conclusion about what is meant by particular words within a general comment?
I tend to personally try to strategize back and see what's happened through the general comments history, because it's the treaty body. So it's the same body of experts. In most instances, over a few years, those experts don't change. So it's the same voices and minds making those decisions. And it's interesting to see how the wording develops and whether it changes and why it might change. Certainly the history of general comments is binding upon the CRC itself in terms of the committee. And I think that it's highly likely that they're going to follow what they've previously said. So you can take everything together to accumulate an argument, rather than just using the last one.
And I think there's an example of this, isn't there? Because leading up to this general comment on animal violence are some concluding remarks historically which mention animal violence. I think there was one in respect of Tunisia in 2021, wasn't there? So, I mean, that was a concluding remark, which is less persuasive, as it were, legally than a general comment. Is that right?
Yeah, so you did have this history. It goes back to Colombia in 2015, where there was concluding observation after concluding observation. And then finally you get this general comment 26 that contains the statement. And that is a huge shift, because it moves from that status of being, kind of a conversation, recommendations between the committee and the states, to then being a general statement, which is applied to all members that have ratified the CRC.
So that's the reason, isn't it, why animal welfare lawyers are now really, really interested in general comment 26.
Yeah.
If we look at the next slide, general comment 26, I think that, Erin, was the slide about how countries, how conventions
is that our map?
Spread out, is it? I think you've got a map here, haven't you, telling us which states are signatories, which have done no action, etc. So we can send that copy out to people so they can see who signed up, as it were.
Yeah.
The next thing we were going to look at, though, was the context of general comment 26. This is a really wide-ranging general comment aimed at children's rights and the environment, isn't it? And it's focusing on climate change. Because I think it's about 120 odd paragraphs, and the comments that we've looked at are paragraph 35, freedom from all forms of violence, comes within a view of the environment and degradation of the environment. So if we look at the objectives of general comment 26, they are to emphasize the urgent need to address the adverse effects of environmental degradation, with a special focus on climate change, on the enjoyment of children's rights, promote a holistic understanding of children's rights as they apply to environmental protection, clarify the obligations of states of the Convention and provide authoritative guidance on legislative, administrative and other appropriate measures to address environmental harm with a special focus on climate change. And the focus within that on animal violence is on within the context of biodiversity and the natural world, and how the degradation of that impacts on children's rights. That's the general context of General Comment 26, isn't it?
Mm.
And I think we've looked at the lead up to animal violence in previous concluding remarks you've talked about. But Amanda, I think you were going to look at the best interests of the child, because the way General Comment 26 is set out is it looks at the impact on environmental damage and biodiversity in the natural world through the different articles within the convention itself. So best interests of the child is Article 3, and that's dealt with at paragraph 16 and 17 of the general comment. So the general, were you going to look at that, Amanda, or do you want me to look at that?
I'm happy for you to.
Okay. Again, very wide-ranging in the context, which leads into protecting children from harm. I'll just read part of it to you. Determining the interests of the child should include an assessment of the specific circumstances that place children uniquely at risk in the context of environmental harm. And the purpose of assessing the best interests of the child should be to ensure that for the full and protective and effective enjoyment of rights, including the right to a clean, healthy and sustainable environment. So it's, again, very wide-ranging and tying in what I think we see in family law, don't we, Amanda? We talk about best interests of the child, and you can see that reflected in our Children Act. So part and parcel of implementing General Comment 26 is referring to how the child's best interests need to be protected through protective measures.
I think you can also actually see that kind of change in the concluding observations over the years, because there's Colombia, Mexico, France, Peru, Ecuador, Spain, Portugal came before Tunisia. And in 2021, so that's from 2015 to 2021. And then in 2021, you have Tunisia. And that's where you see a shift, because previously, I think in all of the other cases, the concluding observations are looking at this issue of children witnessing or participating in violence against animals, and they're seeing it as an issue of children witnessing violence. I think the technical term is lost to me, apparently. But it then shifts, and then it becomes the best interest of the child. So it falls under that different article, just as you get to Tunisia, and Tunisia precedes General Comment 26. And I think that's quite an important change, because best interest of the child is much more general. It can apply in all circumstances. And that's, yeah, it's a really important step.
And Amanda, you were going to look, weren't you, at Article 6, paragraphs 20 and 23, I think.
That's right. I mean, I was curious about whether it's controversial at all, because it is quite an expansion, and for our purposes, a good expansion, but quite an expansion of a legal recognition of the rights of the child, extending much further than they have previously. You know, beyond a right to life, recognition of that right to life includes, as the set out at paragraph 16 and 17, and 20 and 23.
It absolutely is. I remember when I first came across the whole argument, my first opinion that I wrote basically summarized that same thing, that it wouldn't come through in a general comment because it is too expansive. And that's not the nature of those general comments. The general comments shouldn't be extending the original convention. But it's just slightly changing. It's evolving in particular ways that I think are being monitored. But it's also up to us, I think, to decide how it's implemented. So I guess that's the difference here, is that each state gets to choose how they implement it. So the right might not look the same in every place. And I think that's also important when you come to look at Indigenous practices and, you know, the involvement of animals in those practices. It does have to look different in every place. And what is called traditional, I'm sure we'll get onto all of these questions later, but there's not going to be the same rule in every country. So there has to be that kind of push and shove. But one of the most, I guess, bold aspects of it is that they are essentially moving human rights onto animals. And personally, as an animal rights advocate, I have always aspired or looked forward to there becoming a convention for the rights of animals as their own rights bearers. So there's that argument that you have about, if we do go forward with this, there's an entity that is gaining a right on the back of another person's right. And that's not really in sync with how we view human rights. However, this might be the first step to the UN recognizing a need for human rights for the environment and human rights for animals separately. It's definitely going to be a process.
If there is this flexibility, though, as to how a state implements this in line with traditional practices, isn't there a risk that because they're individually implementing them, they can pick and choose?
There absolutely is. And at present, I think that's what's happening. I do think that across the world, we see a lot of states that have superficially signed up to UN conventions and are not implementing their rights. We see that everywhere. And it is interesting, this notion of, should a state be pushed out of the UN for not having complied? And yeah, I mean, we saw that Russia, I think today, getting pushed out of the Human Rights Council. So it's there's a lot of different discussions around how we manage that. But I think that if we were to create the same system that we have with the European Convention of Human Rights worldwide, I think we're doing a disservice, because not everybody's European, for example. I think the idea of universal human rights is extremely important, but it's also extremely nuanced, and we need to do a lot of work to manage that. I personally think it falls more to the citizens to be lifting up their rights and implementing their own rights to ensure that they are gaining that nuance instead of just state leaders.
So, Erin, I suppose this takes us to how, as lawyers, would we define violence and how other people define violence. So if we go to the next slide, these are some of the kind of areas that we start to have to look at, which a lot of them are controversial, a lot of them are difficult, a lot of them are seen in different ways. And I know one of the things, first thing Amanda said to me when we were talking about this webinar was, where do you draw the line? What does it mean? So I know when I first started looking at General Comment 26 as a lawyer, I tried to think about what did we mean by violence. I looked at it because it was under Article 19 of the CRC, and therefore it was more of an exercise of parental responsibility. So a classic example would be bullfighting. Could we say you can't take your children to bullfights as an exercise of parental responsibility? But I don't think that's the way you interpret conventions, is it? I think I've come to know that actually you interpret that much differently. So it's not simply about, although Article 19 is really about within the family and what happens within the family, actually General Comment 26 takes it outside, and general comments do, don't they? So they take it from a private space to a public space. And bullfighting's a really good example, isn't it? Of lots of things, because I think you're going to tell us there's probably been some attempts to get Spain and other countries to stop. And of course, Spain will say, well, it's a sport. It's part of our culture. So what do we do with that, with General Comment 26?
Yeah, I do think that it's extremely difficult. And so I think it was the Tunisia concluding observation. There are too many of all of these materials. I'm pretty sure it was Tunisia that said societal violence. And that was the term that really threw me, because I was like, what is societal violence? Who does societal violence? Like, where does it come from? Who's responsible for the consequences of it? But that really spoke towards the ideas or the examples that you see in so many countries, such as the shooting of street dogs, stray dogs, anything that's happening in that public space. So I do think General Comment 26 takes it very clearly into the public space. I think that conventions generally do that. They are obligations on the state to make sure that the rights are enjoyed by every citizen in their country. So it's absolutely public and it's absolutely private with family law. When we look at bullfighting, I think I was pretty shocked to see that strain of cases come through, because to my mind, I would associate that as a traditional practice or a cultural practice. And we tend to shy away from actually defining what those terms mean, and certainly what they mean universally. Coming from an Indigenous rights background, it's quite alarming, really. As much as I would want to see no harm done, we have to get a bit of a foothold in terms of what societal violence looks like and is, and what is a tradition, what can be traditional. Because I've heard stories in Iceland with the whale hunting, that what was traditional was the collection of whale meat from the shore rather than actually hunting the whales. So when they say whale hunting is traditional, it doesn't really apply. It's whether, sorry, go.
No, sorry to interrupt you, but I mean, it's funny, isn't it? Because if we look at our list, we've got fishing. What's the difference between fishing and whaling? It depends, doesn't it, where you are and what your culture is in some ways. But you could say both of those are violence against animals, couldn't you?
I think you'd find a lot of people that would say so. And I think there's a huge movement towards the sentience level of certain animals. And I know that there's a particular website, I can try and put it on a list for everybody, that grades a country's kind of level of respect towards different animals with sentience. It's incredibly interesting, but it's also very disturbing at the same time.
And I guess, Marcia, you and I were talking about how we would use this in our practice, whether we can use this in our practice, how we use it in our practice. And I don't know whether you had any further thoughts on that in terms of.
Yes, I mean, if we look at the next slide, I think we set out some implications for UK law if we followed it through. Children Act, we have within the Children Act definitions of harm and definitions of significant harm. And one of the things if we were reflecting and if we signed up to and ratified or started to interpret what we mean by significant harm using General Comment 26, we would be saying, wouldn't we, that for children to see any kind of violence against animals should come under at least harm, if not significant harm, as per definition. Do you agree, Amanda? Is that the kind of thing we would be looking at?
Yes, and I think the recognition that there's often a correlation between abuse of an animal and abuse of family members. And so we might not see the bruises, but we might see them kick a pet and ask the questions of ourselves. And I'm sure social workers may need, if they don't already, to incorporate this in their training. I don't know whether the police have it in their training, they probably do, and we're not aware of it. It's certainly what we see in the courts is there's often that link where a pet is used also as a manipulative tool, potentially. Yeah. We define emotional abuse of, well, come and live with me and you can have the dog, but the dog's not going anywhere, to manipulate a child. And should that be part of the overall picture that we're looking at when we're looking at children?
Because domestic abuse in particular, I mean, I try to bring it into the law under controlling and coercive behaviours, but some states in America, I think, have an abuse of a family pet. It comes within the definition of domestic abuse per se. And you can see how using General Comment 26 might create that shift, rather than have to link it quite laboriously through different behaviours. Just, well, there it is, it's domestic abuse, which would be interesting, wouldn't it?
Well, we'll have to run it, won't we?
I'm trying. And again, I suppose the exercise of parental responsibility. Are you taking your children to events that you really shouldn't be taking them to, that involve, dog fighting or whatever? That would be seen as harmful, wouldn't it now?
That was actually, sorry, Amanda, that was in France. So the issue of, I'm not sure if it was bullfighting, but it was actually the concluding observation said the physical and mental well-being and development of children exposed to violence, including on television and in certain performances such as bullfighting. That was what so that's what France is being recommended to fix in their next report. And I think that inclusion of witnessing it just on television is a huge, another huge shift from what we're currently fighting at local levels. I know in Australia, there's a lot of live exploitation that, children are seeing in their lives anyway, but they've got, they recently had a horrible news report on it, which would have met that requirement. And it's going to be very interesting to see if states are going to be able to use this in their domestic cases.
And just moving on from family law, so we can finish up on time, part of the general comments looks at education and the rights for children to be educated in respect of animals, degradation of the planet, biodiversity. There's also really interesting paragraphs on children's right to play and recreation, which includes contact with animals in interaction with the animal world. So that, again, there are different areas, aren't they, where we can start waving general comment 26 about if we when we get the opportunity. And of course environmental law, because it is actually a general comment in respect of climate change. There are going to be a whole range of things that this can be raised in. You know, we've put up health and safety law, farming, I mean, food production, the way we kill animals, lives, you know, non-stun slaughter, all of those things. That this is how wide-ranging this general comment is, isn't it? Which makes it quite exceptional.
It's I mean, the collection of concluding observations that precede it. But then, you know, that is what we're talking about, is a tiny little sentence that comes at the end of a paragraph in general comment 26, and the rest of the comment, it's an incredible issue for them to have gone into, very timely, and hopefully will be prompting further legislation. To be honest, I think there's another convention that's needed here from the UN, and whilst we're waiting for that, I think we have to focus on how do we implement this at the domestic level.
So Amanda, are you going to we need to get into the High Court and start using it, don't we? All right, look, I think probably that's enough information for tonight. We've got a couple of questions. Shall we deal with a couple of questions? One is from Deborah. I think it's more of a comment. She says, in February 2023, Azerbaijan were issued concluding observations to stop shooting dogs in public due to the harmful effects on children. Do you know anything about that, Erin?
I know that this is an issue that is occurring in a lot of countries now, and I absolutely think that that meets the requirements, or it's an example that fits as a violation of the CRC. It's a violation of the children's right to be protected from violence, because they're clearly witnessing these brutal slaughter. I really don't think there's an argument against it. I think the states that are involved it's part of this, I really do see it as a cleansing operation. And, you know, the UK did the same thing. I think, you know, Brazil cleared their homeless population ahead of different events. I think there were 6 people that were killed in that example. And in the UK, you know, when anything royal happens, they clear the streets of homeless people. And it's the same thing in a lot of different countries. Morocco is one of them. I think Turkey also has examples where they're cleansing or clearing the streets before certain tourists arrive, before big events happen, before conferences, sporting events happen.
I mean,
so
there's
there's
a big issue coming up, isn't there, about the FIFA World Cup?
Exactly. Even when the bid is going on, or the Olympics, when these events start to go ahead, you know, the Olympics and FIFA, they commit to observing human rights. But as an international community, we really have to watch those member states that are participating. I'm not a football person, so I've already forgotten who FIFA is being hosted by now. It's Morocco, Portugal, and Spain?
It's Morocco, Portugal, and Spain, yes, are going to be holding the World Cup. So it's Morocco, isn't it? That has targets, doesn't it? Clears.
Yeah, and I'm
goes
sure
out and shoots dogs.
I'd be interested to know what's happening in other countries. Yeah. I think all of us are liable, honestly. We're all watching these events. We're all attending them.
So one last question, I think, before we finish. I don't know who it is. Amanda, I'm going to hand this over to you. If someone attacks the family dog, I think it means, will that affect chance of the child being placed in his care.
I would have thought it's a factor that would.
I think that's right. I think there'd be a lot. I think it's more complex than that, but I think we would probably put it in our schedule of findings, would we, Amanda?
You would.
All right, guys. Look, I think we've come to the end. Thank you, Erin, so much for helping us out on conventions and how they work. And thank you, Amanda, and thanks everybody for watching. Remember, the webinar will be posted up in the next few days. Thank you very much. Bye-bye.
Thank you.